delivered by the renowned legal scholar, Professor Dr. Upendra Bakshi. Some of prestigious speakers who delivered deliver lectures in this lecture series are Honorable Justice P.N. Prakash, Judge, Madras High Court; Honorable Justice Chelmeshwar, former Judge, Supreme Court of India; Justice Dr. S. Muralidhar, Delhi High Court; Shri P. Sainath, Senior Journalist; Mr. Arvind Datar, Senior Advocate, Supreme Court of India. This is the 19th edition of the memorial lecture, and I cannot, because of the paucity of time, take all the names. In recognition of changing horizons in legal education, this year, the theme of the Remembering S.P. Sathe event is Empowering Governance and Justice through Artificial Intelligence, Balancing Innovation with Accountability. This year, as a part of the event, the national conference is scheduled for today and tomorrow. The conference is now being inaugurated by the memorial lecture on Eliminating the Non-Player Character Energy in the Indian Judiciary, which will be soon delivered by Honorable Justice Dr. Dhananjay Chandrachud. It gives me immense pleasure to have with us Dr. Justice D.Y. Chandrachud, former Chief Justice of India, who has kindly consented to deliver the memorial lecture. I welcome you, sir, on behalf of Indian Law Society and ILS Law College, and on my personal behalf. I also extend my warm wishes to all the attendees of the memorial lecture. I am sure this lecture and deliberations in the conference will be an enriching experience for all of us. Thank you for being patient for my speech.
Thank you, ma'am, for sharing that with us. Next, I invite Ms. Vaijayanti Joshi, Honorary Secretary, Indian Law Society, to deliver the chairperson's address.
A very good morning to all of you. Justice Dhananjay Chandrachud, former Chief Justice of India, and our guest speaker today, Shri S.V. Kanetkar, Chairman Governing Council of the Indian Law Society, Dr. Deepa Paturkar, Principal ILS Law College, Justice Sadhana Jadhav, and Justice Shalini Phansalkar Joshi, members of the Indian Law Society, faculty and staff members of the ILS, students, distinguished invitees, ladies and gentlemen. On behalf of the Indian Law Society, I welcome you all to the 19th Memorial Lecture held in honor and memory of Professor S.P. Sathe, who was the principal of this college for nearly 15 years or so. He was also an alumnus of the ILS Law College, and we are very proud of this alumni. I take this opportunity to offer our humble tribute and pay homage to the legendary scholar of administrative law, jurisprudence, and constitutional law. As Professor Upendra Bakshi has rightly described him, he was a jurist in the true sense of the term. I was very fortunate to have a very long association with him. He joined the Law College in 1976, and I was then a student in the second LLB of this college. I remember his lectures in jurisprudence, administrative law, and constitutional law. The learning experience is still fresh in my mind. He was my boss when I started teaching as a part-time teacher and subsequently as a full-time teacher in the college. And when I became the principal of the college in 1993, he became my friend, philosopher, and guide. Since 1976, we traveled a long, wonderful journey together till his untimely sad demise in 2006. I had experienced his passion for imparting socially relevant and professionally desired legal education, his unwavering faith and commitment to rule of law. His contribution to legal aid movement was unique. Under his leadership, the first ever legal aid center in the country was established in the ILS Law College in 1976 before Article 39A was added to the Constitution. He was also the first director of Institute of Advanced Legal Studies. His contribution in shaping legal education will be remembered forever. In order to carry forward his scholarship, remembering S.P. Sathe event is organized every year dedicated to a specific theme. The theme for this year is Artificial Intelligence, AI. Friends, every now and then, almost every morning, we open the newspaper, we read any magazine, put on the TV, and we find that we keep on talking about, reading about AI, its impact on our life, redundancy of human being in many fields, loss of job opportunities, upgrading of skills, etc., etc., etc. Artificial intelligence is part of science and technology. Intrusion in human life by science and technology is not something new. It has been there and will continue to be there for all times to come. What is new is the immeasurable scale and the speed at which the intrusion is taking place. The impact of technology is always positive and negative. Few decades ago, horse carriages, bullock carts were replaced by automobiles driven by men. So initially, animals were replaced. Now we are moving towards replacing human beings by having driverless cars, automation, machinery, etc. So human intervention wanted to be minimum. We are moving towards replacement of human beings. Science, technology are inseparable parts of our life. Nobody can stop or halt innovation in it. As long as it works for humanity, it is welcome. Much depends on who controls it. The world has experienced the ghastly, fatal outcome of atom bomb explosion. But we therefore don't and can't discard atomic energy. Science and technology are means and tools to serve humanity, and they are not the end in themselves. What therefore becomes relevant and challenging is balancing innovation and accountability. Probably that is the part of the theme also. And at the end, I am tempted to quote Albert Einstein, who said, I quote, "The world had two inventions from the century to choose from, the atom bomb or Gandhi. Today, the atom bomb stands for innovation, that is AI, and Gandhi for accountability to humanity." So friends, thank you very much, and I welcome Justice Chandrachud once again for being with us. Thank you.
And now comes the most awaited moment, friends. We are indeed privileged and honored to have with us Dr. Justice Dhananjaya Chandrachud, a visionary jurist, a champion of constitutional values, and an ardent believer in progressive jurisprudence. There are some luminaries who need no introduction, friends, and Dr. Justice Dhananjaya Chandrachud is undoubtedly one of them. Yet, it is only befitting that we take a moment to reflect his extraordinary contributions to Indian jurisprudence. As the 50th Chief Justice of India, he has been at the forefront of shaping a judiciary that is both progressive and inclusive. From his landmark judgments on constitutional morality, privacy, gender justice, disability rights, and individual freedoms, to his pioneering efforts in digitizing the judiciary and integrating technology into the legal processes. Justice Chandrachud has redefined the way law interacts with society in many ways. Under his leadership, the Supreme Court took monumental steps towards live streaming proceedings, e-filing systems, and ensuring access to justice through technology-driven reforms. His vision for modern, responsive, and equitable judiciary continues to inspire generations of legal minds, making it an absolute honor to have him deliver today's memorial lecture on the thought-provoking theme, eliminating the non-player character energy in the Indian judiciary. May I now request Justice Chandrachud to deliver the 19th Remembering S.P. Sathe Public Memorial Lecture. May we have a round of applause, friends.
very good morning. Thank you for coming in such large numbers and for being here, though everybody cannot be seated. Mr. Shrikant Kanitkar, the chairperson of ILS, Dr. Vaijayanti Joshi, secretary of the Indian Law Society, a distinguished daughter of a very distinguished principal himself, Principal Dr. Deepa Paturkar, my former colleagues in the High Court of Judicature at Bombay, Justice Sadhna Jadhav and Justice Shalini Phansakar Joshi, distinguished senior lawyers including Mr. P. Narayan, all the faculty, staff of the ILS Law College, Pune, and above all, my dear students. I'm truly delighted to be back at ILS Law College. I've had a long association with ILS in Pune. Having come here as a young judge of the Bombay High Court and wondering what I should say before such a talented set of young students, coming and attending lectures by others, including the 70th birthday celebration of my own father when Chief Justice Ahmadi and Mr. Ram Jethmalani came here to grace a roundtable dialogue with Principal Sathe. I have delivered 2 lectures here in 2020 and 2022 in the memory of the former Chief Justice of India and my father, Yashwantrao Chandrachud. Growing up, my father, who later served as the president of the Indian Law Society, would often hark back to his time as a student of ILS Law College. He always remembered the time when, in those cold days of the Pune winter, when we were not affected by climate change, he had mastered the art of putting his 2 hands in his coat pocket and riding his cycle from our joint family home in Budwarpet to ILS to avoid the chill of the winter. This 102-year-old institute was built to impart legal education to Indian masses under colonial rule. Over 24 years and nearly 10 months as a judge, I've seen enthusiastic and intelligent ILS students at my office as interns, and most recently, as one of my law clerks, Nauman Beg, who still fondly recalls his time at ILS, buried in the books at Gharpure Library and walking around the lotus pond between classes at the Lakshmi building. In its long history, ILS has produced giants like Chief Justice P.B. Gajendra Gadkar, Chief Justice Y.V. Chandrachud, Chief Justice E.S. Venkatramaya, whose daughter, Justice Nagaratna, has been a very dear colleague of mine on the bench of the Supreme Court. Countless judges of the Bombay High Court and other high courts, including Justice Mridula Bhatkar, chief ministers, members of parliament, of the legislative assemblies, governors. ILS most recently gave the Delhi High Court a judge, Justice Tejas Karia, from its fold. I have had the pleasure of engaging with the scholarship which has been produced by members of the ILS faculty. In Vikash Kumar versus UPSC, a judgment which I delivered in 2021, the Supreme Court allowed a person with disability to use a scribe in his UPSC examination. I used the work of Professor Sanjay Jain, former principal of ILS Law College and presently professor at NLSIU Bangalore, to understand the fallacy in the argument that disabled students may game the system and cheat in their examinations by misusing reasonable accommodation. More recently, in Society for Enlightenment and Voluntary Action versus Union of India, in 2024, the Supreme Court made exhaustive 21-page long guidelines to various departments of the Government of India to effectively implement the Prohibition of Child Marriage Act 2006. In understanding the history of child marriage and the patriarchal influence on the reformers who agitated against child marriage, I benefited greatly from the scholarship of Professor Jaya Sagade, who has served as Vice Principal of ILS Law College. Let me begin by dwelling on Professor Sathe's legacy. Professor Satyaranjan Sathe, in whose memory we convene here today, was not only one of the finest from ILS, but also one of the finest scholars the legal fraternity has produced. Professor S.P. Sathe had a humanizing influence on the law. He was the principal of ILS Law College for 15 years between 1976 and 1991, after which he founded the Institute of Advanced Legal Studies to promote legal research and make law accessible to non-experts. Professor Sathe was not only an institution builder, but a visionary, and also rooted his work in a moral framework. Professor Sathe wanted to fundamentally change our approach to the law by promoting critical thinking and injecting a human rights discourse. This was long before the critical legal studies movement, particularly in areas like gender and race, assumed importance in the United States. In its report published in 1993, the UGC LLB and LLM Curricular Reform Committee in Law, with which Professor Sathe worked closely, developed the notion of law students as soldiers of social justice. His method was dialogical rather than authoritarian. Today, this approach is adopted by all the leading law schools in India and is the defining spirit of NLSIU to create social engineers. Professor Sathe's views on gender, social activism, judicial activism, public interest litigation, constitutional law and administrative law have illuminated entire generations of lawyers, civil society activists, and academics. Despite his immense contributions, when one thinks of S.P. Sathe, he is remembered for his gentle smile and hospitable attitude. Professor S.P. Sathe stood for courage and academic integrity. He would express the fiercest opinions in the most critical moments, yet always with a smile and a gentle tone. Professor Sathe was not alien to difficulties. His strong stance on social justice required both mental and also, oddly enough, physical strength. He once landed in a physical scuffle with his vice principal, who had ideological disagreements with him. This by no means is an endorsement of settling scores with fists in masala Bollywood style. But Professor Sathe could use his 2.5 kilo ka haath if necessary. Despite operating in an orthodox environment, Professor Sathe continued to approach his detractors with love and compassion. As a staunch feminist, Professor Sathe was instrumental in setting up the Nari Samata Manch, one of the first autonomous women's groups in Pune. He was also associated with the Maharashtra chapter of People's Union for Civil Liberties and the People's Union for Civil Liberties on the national plane, an organization which was truly honed with great authority and compassion at the same time by Mr. V.M. Tarkunde and Jayaprakash Narayan. When Professor Sathe saw that men were growing a resentment against feminism as a backlash against progressive gender justice laws, he established the Dr. Satyaranjan Sathe Purush Samvad Kendra, Center for Dialogue with Men, to engage in a sensitive dialogue with men. He enabled them to understand gender justice laws through an accessible and humanizing lens. This heightened degree of compassion for those who disagreed with him defined Professor Sathe. His non-antagonizing and inclusive approach would reflect in his work and pedagogy. It also became synonymous with the academic and student culture at ILS Law College. Openness and diversity of views are the hallmarks of any successful institution. Professor Sathe left behind a culture which would be fertile for creating humane leaders in the law and beyond. Institutions like ILS are vital because they lend space to all intellectually honest viewpoints without browbeating critical voices, and while keeping progressive constitutionalism alive at its core. We risk losing all this only at the peril of our institution. My dear former law clerk Norman himself told me of the time when a pride march was to be taken through the campus of ILS Law College. The then principal was a little reticent with the idea of a pride march, but Deepa Paturkar felt that this was something which must be accepted and allowed within the portals of the ILS Law College. So she walked up to the principal and stood by her own convictions to impress upon the principal the need for having a pride march. Of course, COVID-19 intervened, I believe, and then the lockdowns took place. When I was approached to deliver this lecture on the theme of AI's interplay with justice and governance, I thought about Professor Sathe's leadership as an institution builder. Justice and governance are central to all institutional functioning, whether at the level of a college or a branch of the government. When it comes to the Indian judiciary, we think of the key role which it plays in our democratic functioning and the daily lives of ordinary citizens. The judiciary is an active participant in India's democratic dialogue. It lends a voice to the politically voiceless, lends a hearing to issues which may not be at the discussion table in the other branches of government, and resolves disputes by rational discourse under existing laws. This multifaceted role requires an efficient, transparent, and proactive approach by courts. Very often, as a judge of the Supreme Court and as Chief Justice of India, when I sat with brilliant young minds from across the diversity of India, who are my colleagues, and I allowed an argument to go on for too long, my colleagues, if they were drawn from the north, would say, "Chief," or "Brother," when I was not the chief, "Bahas band karo, bahut ho gaya." And I would still allow the last word to be said by the lawyer. And while climbing down from the dais, I would tell my colleagues, you know, very often you don't do justice in the outcomes in courts, but in the process which you follow. And so much of the healing which takes place is in giving people a voice to be heard through rational dialogue. Anyone familiar with gaming, as most of my young friends here are, may have heard of NPCs, or non-player characters. It refers to a player who serves no critical functioning. Blending in the background of the game, NPCs are like the policemen in GTA Vice City, who can be let loose with a simple cheat code, "Leave me alone." The non-essential, dispensable, and uncritical functioning of NPCs have gained them a recognition on social media discourse, where it is hurled at only viewpoint or person who is deemed irrelevant. Think of any group projects you were in and you will remember NPCs. Only 2 people would work, while the NPCs would only come to share in the grade. An NPC is that one guy who contributes nothing to the group. NPCs are marked by inertia, lethargy, and a general lack of intelligence. When I was a young school student in Mumbai, we were given a project to prepare on Australia. I was the chair of the project in my 4th grade, and I put together all my friends, like-minded friends, with whom we would share a snack to be part of my team. I realized that out of the team of 7, we were effectively left only with 2. The other 5 were non-playing characters. On the last evening before the project had to be handed over, we had barely commenced the work on the project and we were down to 2. at about 8 o'clock in the evening, one of my friends said, I think you better go home and let me do the project on my own. So I too became an NPC when the project was completed by the remaining member, the sole member of the team. When we talk of the judiciary, many perceive a core NPC energy in myriad procedures and mechanisms at the court and in adjudication. You have court staff who do the work of NPCs or don't do the work which an NPC has to do. So often I felt that we are terribly overstaffed in the Indian judiciary in terms of administrative staff, with a clamor for more and more and more recruitment. Likewise, though we claim that we have one of the lowest judge to population ratios in the world, which is a truth and not a fallacy, that does not account for some of the NPCs in the Indian judiciary as well. Because there are no wages of disincentive for people who do not perform, whether administratively or judicially. And therefore, I thought that this issue must be addressed head on. I shall speak on eliminating the NPC energy in the Indian judiciary. First, I will speak on the vitality of creating a digital ecosystem in the Indian judiciary to make it innovative, efficient, and citizen-centric. Second, I will speak on the ability of artificial intelligence, AI, to enhance the efficacy of the justice delivery system. Lastly, I will contemplate on some of the concerns and blind spots we have in the realm of AI. First, digitizing the judiciary. The call for digitizing the judiciary has been in vogue since 2006, when the e-courts project was launched as part of the National E-Governance Plan. The focus in the initial phases of the e-courts project was to ensure that courts have hardware devices, such as desktops and printers. LANs were later introduced for better internet connectivity. Despite some progress, the judiciary remained largely undigitized. When the world was struck by the COVID-19 pandemic, it brought about a sea change in our approach to judicial work. In the face of incredible odds and under a life-threatening pandemic, the courts responded with grit, innovation, and alacrity. After all, justice cannot take a day off. The judicial function is vital to the life stream of the nation. There was no stopping that. My Chief Justice, Justice Bobde, called me the day that the first lockdown was pronounced. We were few in the court and said, what do we do? So we said, we have to continue to function. Either we function within the court, despite the grave dangers that some of us will perish, or we'll use the existing infrastructure for running the court. And we ran the court with a few initial hiccups. One of the initiatives was accelerating the move towards an e-judiciary and the adoption of a systematic approach towards technological integration, through which virtual hearings were started in the Indian judicial system for the very first time. The rapid response of the Supreme Court in adopting technology and devising e-courts, online hearings via video conferencing, standard operating procedures for urgent hearings, live streaming, and e-filing ensured that the interruption in the court functioning was brief. During the pandemic, the district courts heard 16.5 million cases. The high courts heard 7.58 million cases on a virtual platform. The Supreme Court heard 6,79,835 cases through video conferencing. Among these cases, the Supreme Court and High Courts actively monitored the areas of human rights violations during the pandemic. The vision document of the Phase 3 e-courts project was launched in the backdrop of the pandemic. As chairperson of the E-Committee of the Supreme Court of India at the time, I worked with a brilliant and dedicated team of techno enthusiasts, both within and outside the judiciary, to vision a judiciary which is natively digital. As Chief Justice of the Allahabad High Court, I had undertaken to digitize over 1 crore files at the High Court. But the task cut out for the Supreme Court was much more grand. When we began digitizing in the Allahabad High Court, files, including in murder appeals of the 1980s, were literally strewn all over the place, including under the staircases, and then doused generously with spit from pan. So we began digitizing in that background. A natively digital ecosystem imagines technology to precipitate so deep into the judicial infrastructure that no targeted thought has to be put into digital modernization. It postulates a system which produces digital solutions by design. Digitization became one of the central solutions to case pendency, case management, maintaining bulky physical records, and delays in listing, among others. When we heard the Ayodhya case, the record was 30,000 pages, and we thought, wow, 30,000 pages. By the time that my tenure on the bench of the Supreme Court was ending, 15 to 20,000 pages was par for the course of a judicial record. But all of us sat together with nothing more than a pen drive, and in the modern computers and laptops without a pen drive, with a connection to the cloud infrastructure. Digitization must be made available at the level of the district judiciary, which deals with the majority of our cases and is the first point of contact for any litigant. The incorporation of technology in the Indian judicial system has not only made judicial institutions more accessible for all citizens, but it has also acted as a tool to reach out to those who lack access to technology. With virtual and hybrid hearings, advocates or litigants can appear before the courts from any part of the country to argue their case. The Supreme Court also has started live streaming of constitutional cases, utilizing AI software for live transcription of hearings and translation of judgments in multiple languages. This ensures transparency in judicial proceedings. The Supreme Court is situated on a road which very aptly is named by one of the greatest freedom fighters, Lokmanya Bal Tilak. It's called Tilak Marg. But what technology has done is to ensure that the Supreme Court does not remain the Supreme Court of Tilak Marg or the Supreme Court of Delhi, but truly is Supreme Court of India. Chief Justice Muralidhar is going to be addressing you tomorrow. There was a demand for benches in the state of Orissa, as you have demands for benches all over Maharashtra. And he said, why should I give you one bench? I will give you, if there are 36 districts, I will give you 36 benches, simply by decentralizing the administration of justice through the use of technology. So likewise in the Supreme Court, this decentralization has given us young lawyers from across the country who have a fundamental connect with the client, whom the clients trust as the first point to which they have gone for arguing before the Supreme Court. All that they lack are resources to come to Delhi, because the clients cannot afford for them to go to Delhi. The clients cannot afford the high cost of a senior counsel in the Supreme Court. But technology has given us these options. Adopting technology has allowed the Indian judiciary to make its judgments and case details available across all three tiers of the judiciary on the National Judicial Data Grid. It has set up e-court services, e-filing, e-payments of challans and court fees, digitized processes in summons, warrants and arrests with the National Service and Tracking of Electronic Processes, (NSTEP), and made the process of sending bail orders to district courts and jail authorities faster with the help of fast and secure transmission of electronic records, faster as we called it. The easiest thing in the world is really for a court to pass an order granting bail in the Supreme Court. But how do you ensure that the bail order is transmitted and actually implemented by the superintendent of jail in one of the districts in the country? So we use blockchain technologies, blockchain to ensure that these bail orders are authenticated, that they cannot be fabricated. And a response is received by the monitoring cell in the Supreme Court which tells us when was the corresponding order passed by the Sessions Court implementing the direction issued by the Supreme Court, and when was it actually communicated, and when was the under trial actually granted the benefit of bail. Besides dealing with digitization on the administrative side, under the e-courts project, I also had the opportunity of dealing with it on the judicial side. In Sarvesh Mathur versus Registrar General of the Punjab and Haryana High Court, the Supreme Court mandated virtual and hybrid hearing facilities to all high courts, district courts, tribunals, including consumer dispute and company law dispute tribunals. In gathering data through affidavits, it was disheartening to see a tech-averse neo-ludism pervading the Indian judiciary. And this, my young friends, is true and it's a reality. You have to confront mindsets and attitudes. There were high courts which said that you will get access to the link for a virtual hearing only if you are above 60 years of age. Why? Do people below the age of 60 do not deserve the benefit of a virtual hearing? Does a pregnant young girl in her 20s not deserve to be heard virtually? Does a disabled person who finds it difficult to navigate the staircases of courts not deserve a virtual hearing? But we are really in a process of confronting mindsets. That was peak NPC energy in the Indian judiciary. There was immense reluctance for something as simple as virtual and hybrid hearings. In fact, in many instances, lawyers were reprimanded for using their laptops, iPads, and mobiles in the courtroom as though they were using them to binge watch Friends or How I Met Your Mother in the courtroom and not for work. I got an email from a young woman lawyer from the Bombay High Court who said that I was trying to research a case for my senior who was arguing a hearing before the Bombay High Court when the judge's usher came and tapped me on my shoulder and said, "Ye iPad use nahi kar sakta hai court mein." And I said to myself, what if a young person is actually watching the news, trying to find out what has happened in the world? How does it affect the functioning of the court? But as I said, mindsets need to change. The achievements of the Indian judiciary so far are tectonic, but by no means enough. The aim of the judiciary is to be completely digitized. I started by speaking on the importance of this digital ecosystem because digitization is a prerequisite to ushering in comprehensive use of artificial intelligence. To think of AI in a silo would be fanciful and unrealistic. For utilizing any new technology, the judiciary must create a fertile ground for its growth. Despite much progress, we still need an attitudinal shift among senior members of the bar and the bench in embracing complete digitization. The project of digitization began with a zeal to democratize the functioning of the courts further and create last-mile accessibility. It seeks to achieve futuristic courts, when litigants and lawyers can access the developments of their case with ease. It strikes a death blow to middlemen who wield considerable power over uninformed litigants. Removal of opacity in the judicial process is a democratic dividend in our society. When I was a young lawyer, we confronted the opacity. It was simple enough to argue a case and get an order from a judge if you had justice in your favor. But the real problem was getting a copy of the judgment from the stenographer. Because the rates varied between stenographers based on number of pages, complexity, or the seniority of the stenographer. And when we started e-certified copies in the Bombay High Court, we confronted a great deal of resistance. But resistance was overcome. The lawyers who are there practicing now will not even remember those times when you had to go to the stenographer and ask for a true copy or a rough copy. Now, The second part of my presentation, I want to dwell on how artificial intelligence will eliminate NPCs, the non-playing characters. The government of India has allocated 7,201 crores to phase 3 of the e-courts project. An amount of rupees 53.57 crores is earmarked explicitly for future technological advancement, including AI and blockchain, across high courts in India up to 2027. AI has been defined as a suite of related technologies powered by algorithms which can perform tasks otherwise requiring human intelligence. We can use AI to minimize cumbersome tasks requiring human intervention by automation. AI can eliminate the NPC energy from the judiciary by making its processes more efficient and seamless. The net saving of human capital and attention span can then be diverted to more enhancing and creative activities. Ask any judge in the district judiciary how much time is wasted on a day by just taking out a roll call of cases which are not going to be heard. This is the NPC element, which is independent of the judge. This is the NPC element which is built in the system itself. The Indian judiciary is undergoing a digital transformation with the integration of artificial intelligence, making legal processes more efficient, accessible, and user-friendly. With the ever-growing backlog of cases, AI-powered tools are stepping in to optimize workflows, reduce delays, and enhance decision-making. One of the key initiatives is intelligent scheduling and case prediction, where AI helps in managing court schedules more effectively. By analyzing historical data, these systems predict case timelines, offering valuable insights into probable outcomes. This not only aids judges and lawyers in better case preparation, but also ensures timely hearings, reducing unnecessary adjournments and delays. And this is not too far from where ILS is situated. Go to the Center for National Excellence of the National Informatics Center here in the heart of Pune, which we inaugurated just a few months ago, and you'll see the kind of cutting-edge research which is being done on the basis of AI for developing the Indian judiciary to the next level. Another significant area where AI is making an impact is automated filing and case management. Filing legal documents is often a tedious and time-consuming process, prone to human errors. With AI-driven document automation and optical character recognition, which is OCR technology, courts can now process legal paperwork with greater accuracy and speed. This minimizes manual data entry, easing the workload on court staff, and improving overall efficiency. Lawyers and litigants benefit from smoother documentation processes, which leads to faster case progression and a more streamlined judicial system. In the Supreme Court, there's a process. When a case is filed, it is given a diary number. When the defects are removed, and that's true in the high courts as well, it is given a case number, a regular case number. Between the allocation of a diary number and the allocation of a case number, several days, if not weeks, would go by. Because the person in charge of the desk, and there would be about 20 of them manning different desks, would be running through a manual checklist, reading the entire paper book to see whether the defects have been removed. Court fee paid, yes, no. Wakalatnama filed, yes, no. Affidavit in support filed, yes, no. Synopsis paginated, yes, no. Pagination done. Margins of so many inches left on the left-hand side, all done manually. And as you can understand, when too much manual work is given to those in charge of our registries, the most resourced of people and clients, the corporate clients, know how to game the system. So I thought, why don't we use AI to carry out this work? And that work has already been initiated, because AI can read probably at a fraction of a point of time that a regular human being requires to do basically a manual task of reading and finding out defects in a case. Legal research. We set up a war room in the Supreme Court containing the nation's data. The War Room tells us what is the stage of defect removal on every one of the 20 plus section officers who was assigned to remove defects. How long have cases been on their desk? 0 to 1 day, 1 to 2 days, 2 to 3 days, 3 to 5 days, so on and so forth. Legal research, a cornerstone of effective legal practice, is also being revolutionized through natural language processing. Traditionally, legal professionals spent hours poring over books and databases to find relevant precedents and judgments. With AI-powered research tools, judges and lawyers can now access case law, statutes, and legal opinions instantly. Additionally, in a country as linguistically diverse as India, AI-driven translation tools, Bhashini, or Suas, which we use in the Supreme Court, are ensuring greater accessibility to legal resources. These tools allow judgments and legal texts to be translated into multiple regional languages, bridging the gap between language barriers and ensuring inclusivity in legal proceedings. All our judgments are written in English. I realize in so many cases that I heard in the Allahabad High Court that the English began and ended with, "May it please you, my lords." After that, the rest of the argument was in Hindi. But we write our judgments in English. The judgments are for the benefit of litigants who don't understand a word of English. They are for the benefit of lawyers who don't speak English as a preferred language. Presented informs human emotions and reactions. When AI takes charge of disseminating information, it will also be capable of generating its own ideas, which may shape human reactions. Imagine a world where the disseminative power of social media combines with the creative power of AI. Would the world we are about to enter be dystopian, or a world where we accept the higher technological forces which govern the destiny of human beings? I've really flipped the quotation by Lokmanya Tilak, which is outside the central court of the Bombay High Court, where he says, there are higher forces which govern the destinies of human beings. And it may be the will of providence that the cause which I subserve may prosper more by my being incarcerated than by my being free. So will we be in now a world where we accept the higher technological forces which govern the destinies of human beings? AI will assume the role of defining the critical dividing lines in our own evolution, deciding whether we live through war or peace, in divided societies, or in a plural, diverse world coexisting with each other, through health or in disease, in a race to capture resources, or as protectors of planet Earth. AI is not just another technological advancement. It's an entirely new kind of agent, capable of making decisions, generating ideas, and even influencing human perception. And that's where the real concern lies. Humans are already prone to mass delusions. In today's age, social media has captured our most valuable asset, namely our attention. Even good morning messages are expressed in meme format, and catchy jingles capture our brains around each festival, from Punjabi hymns during Christmas to complex Arabic poems expressing humorously sung phrases during Ramzan. Social media uses our attention to feed into our confirmation biases and shows us algorithmic content which agrees with our taste and eventually leads us to believe in a certain social and political position. The consequence of algorithmic social media has been that people live in information echo chambers. You go to your library, if you at all go to a library, and pick up a book which sides with what you think. You go and listen to music which sides with what your ear wants to listen to. We don't want to read what we don't agree with, and we don't listen to something we don't like to listen to. The consequence, therefore, of algorithmic social media is that we all live in echo chambers. truth is different depending on which side of the political or social spectrum you belong. The post-truth world has been credibly linked to election outcomes globally and widespread misinformation. AI, with its ability to shape narratives and flood us with hyper-personalized content, could push us further into a distorted version of the world, one where truth is harder to find than ever before. We have seen this pattern throughout history. The printing press revolutionized information sharing, but led to a sharp increase in misinformation and propaganda. Today, AI is poised to do the same, but on an even greater scale. Most of the information we consume is not true, because truth is expensive and often painful, whereas fiction is cheap and easily digestible. Sometimes when I get irritated with the truth coming from my own spouse, she tells me, in this case, truth is not expensive, but truth is painful. AI will be used to create and spread falsehoods, whether for political gain, financial incentives, or simply because it is programmed to optimize engagement. In a world where people are manipulated with junk information, even good individuals make bad decisions. Human obesity in developed nations has been attributed significantly to the power of marketing and easy access to junk food. What about minds which are fed on a constant diet of junk information? Truth for the mind is what nutrition is for the body. AI is more than just a tool. It has the power to shape culture, religion, and our most intimate beliefs. With its ability to process vast amounts of text, AI can digest and reinterpret religious scriptures, offering new interpretations that could reshape faith itself. The past few decades have been marked by a war for human attention, but now the battlefield has shifted to human intimacy. AI can simulate relationships, forge emotional bonds, and manipulate people in ways we have never experienced before. This is not just a possibility, it's already happening. Tinder is now a matter of the past. We are into a new world where intimacy is regulated and manipulated by AI. There are strong commercial incentives for AI to be used for fakery and manipulation, and companies will exploit these for profit unless held accountable. So what's the solution? The answer is not more information. They say that the answer to sunlight is more sunlight. But here the answer is not more information. Flooding society with data doesn't enhance knowledge. It only increases confusion. The real solution is building and strengthening self-correcting mechanisms, institutions which separate truth from noise, just as universities, courts, and independent news organizations was designed to do. Democracy itself is a self-correcting mechanism. Without it, global humanity risks creating a system that mirrors the political equivalent of authoritarian rule, where falsehoods dominate without challenge. AI development has been founded on the investment of billions of dollars. Data centers generate huge carbon footprints as they guzzle power. But AI needs investment in safety, investment in truth, and investment in accountability. It must not disguise itself as human. Companies must be held liable for the harm they cause. AI already inherits human biases because it learns from the data we feed it. If we train AI without investing in truth, we risk creating a force that spreads delusions and actively harms society, not just as a tool in human hands, but as an independent entity capable of influencing our world. Steven Spielberg's 2000 film titled AI is set in a future where humanoid robots, known as mechas, coexist with humanity. The film provides a compelling narrative to ponder over the nature of consciousness, identity, and ethics. One scene in particular stands out, a tender moment between David, a young AI boy, and his human mother, evoking profound questions about the nature of consciousness and the boundaries of human emotion. As David yearns for the love and acceptance of his human creators, we are forced to confront our own preconceptions about what it means to be human and the ethical implications of creating sentient beings in our own image. By no means do I wish to be seen as a neo-Luddite, which I have fought against throughout my 25 years and more on the bench. However, the reality is that AI experts admit that they do not know what to be prepared for, since the consequence of artificial general intelligence is unpredictable. Trust must therefore be placed in institutions with strong self-correcting mechanisms. Science is tested not because it is infallible, but because it constantly admits and corrects its mistakes. Our Supreme Court is trusted not because it is free from error, but because of its ability to self-correct. Admitting mistakes is not a sign of weakness, it is a sign of strength. Nations, societies, and individuals who acknowledge their errors become stronger, not weaker. The AI debate cannot be framed just as a question of technology, but as a debate on questions of truth. And if we get this wrong, the consequence will be unlike anything we have ever seen. In embracing AI, we must ensure that we don't become NPCs ourselves. Revolutionizing the judiciary with AI requires key considerations of privacy, moral ethicality, and humanizing currents. As much as some areas of the law can be automated with the use of AI, others are far from it. An economically disadvantaged student had petitioned the Supreme Court. He had missed his IIT admission because it took him time to collect the required amount and faced technical difficulties when he finally had the amount. He defaulted on the payment of his fees and was stripped of his place at the IIT. In another case, a mother with a child suffering from a rare genetic disorder came before the Supreme Court against her employer, the state, which did not have a child care leave policy. In yet another case, a person with 88% locomotor disability was denied admission to medical college based on mechanical testing and outdated regulations. In each of these cases, a textual assessment of the law would tilt against the petitioners, the poor student, the distressed mother, and the disabled medical aspirant. And yet, in each of these cases, the Supreme Court of which I was a part decided in favor of the petitioners. I would like to believe that there is something inherently human about adjudication, that space for human adjudication will remain relevant even if AI is used for drafting, filing, case management, information dissemination, and administrative efficiency. Conclusion then. The judiciary must strike a balance between leveraging AI for administrative efficiency and preserving the inherently human aspects of adjudication. As demonstrated in the cases above that I just referred, the law is not merely a mechanical application of rules, but a living instrument which must adapt to the complexities of human life. AI can assist, but it cannot replace the empathy, moral reasoning, and contextual understanding that judges bring to their decisions. The judge to the human is like the doctor doing the ward rounds, whose healing lies in the ability to touch the hand of the patient who has been operated. Even to look a patient in the eye who you know cannot be cured, because you cannot heal everything. As in the life of a medical professional who says that you cannot heal everything, so also in the life of the law, you cannot heal every injustice. But healing every injustice is one aspect of social endeavor. the ability to heal feelings of those who have been subjected to injustice is a great hallmark of the human life. As we move forward, we draw inspiration from the legacy of ILS Law College and leaders like Professor S.प. Sathe, who believed in the power of law to transform society. Real-life stories of individuals like Professor Sathe have to be told and to be retold simply because they inspire us in times of flux and stress. You know, our tradition is the oral tradition. That's why I didn't include, apart from three religions, any Indian religion, because we are not exclusively founded on books or texts, but on the oral tradition. Real life stories have therefore to be told and retold. I remember listening to the spinning of the stone Sathe. I'm not sure how many of the younger generation today would remember that also. I remember listening to the spinning of the stone Sathe in our joint family home here in Budwarpet in Pune. The sound of stone turning on stone, the fragrance of the cereal which was being caringly crushed into powder, and the background singing of Ovia. Well, stories and reminiscences provide balm to the soul and faith in our ability to sustain amidst change. The judiciary must therefore shed its non-player character energy. It must not only be technologically advanced, but also be rooted in the principles of justice, equity, and compassion. It's time to hit the button on the judiciary and eliminate NPCs so that no cheat codes are required. Confronting the NPCs within the judiciary is a tall order, because there's always resistance to change, and there are vested interests which will resist change. The journey ahead is fraught with challenges, but with careful deliberation and a commitment to ethical innovation, we can harness the potential of AI. Thank you very much. Namaskar.
It was indeed enlightening, sir, and I'm sure this lecture has cleared a lot of our NPCs of confusion to maneuver our natural intelligence through artificial intelligence. Thank you so much, sir. Now we open the floor for question and answers, a brief interaction. There are student volunteers. Please raise your hand and we would be taking only few questions. Yes, sir. Yes, yes.
Hello. Yeah, good morning.
Before you ask a question, I'll share with you a story. I was assisting a senior when I was a young lawyer in Mumbai in cross-examination in an arbitration trial. So the senior asked me one question. He said, I want to ask you something. He said, you know, when you cross-examine, it was a civil trial, not a criminal trial. He said, when you cross-examine a witness who was given evidence in chief in a civil trial, are you bound to ask him only questions on what he has deposed? So I was a little flummoxed. So the senior said, no. What to answer is the witness's choice, but if it's a partnership dispute, you're not bound to only ask those questions on which that partner has deposed. You're entitled to probe your case through the line of cross-examination of that witness. The reason I'm asking you this is, I have spoken on AI, but I'm open for cross-examination. And your cross-examination need not be based only on the subject of my lecture. You can talk about careers, about futures, about what's a matter of concern, anything.
I would request the people who are asking
Answers will
questions.
be to the best of my ability, so forgive me for any mishaps along the way.
We request to just specify your name and please keep your questions precise.
Yeah, Advocate Abhijit Paranspe. I have started recently the practice. Now my question is about the use of AI, and I'll just quote a notable UK case, which is Harbour versus Commissioner of Majesty, Revenue and Customs. a respondent was found to have cited fake case law generated by an AI system, leading to concerns about the potential of legal repercussions when the lawyer rely on the generated citations without proper verification. And this case highlights the issue of AI hallucinations, where the system produces plausible but incorrect legal information and potentially resulting sanctions for lawyers who use it without due diligence. Now later on they were penalized, it was found, and there were some sanctions against those. Now my question is very simple, that if overuse of AI, we are promoting for e-filing, there are hiccups, but how the system of adjudication will tackle this problem? Because if you are citing fake case laws, now how the system will respond, and it will whole miscarriage of justice, what we say, and it will be a very concern as an advocate.
You know, on a lighter vein, this problem about citing fake cases has always been a problem, with or without AI. My father narrated to me an episode which has really stuck in memory for the last probably 50 years. He says that he was invigilating at an examination, a university examination in ILS Law College. By then he had. One of his cousins or a friend was appearing for the examination. And he just sort of looked into he's not known for his legal excellence. He had to somehow pass the examination. And he found that, he had cited case after case, Arjun versus Bhima, Seema versus whatever. So when he left the hall, he went up to him and asked, he said, all these cases which you cited in your examination, Arjun versus Bhima and so on and so forth on Hindu law, where do you get these cases from? He said, well, you're presuming that the examiner knows that these are fake cases. There was another case where somebody was asked to write something on citizenship. And the student began by saying, citizenship is a very important ship. It's a very big ship. So, the point is that you have as many people who will innovate and try and breach the system, whether you are in a digitized format in technology or whether you're in a physical format. I was having a conference with the Judiciary in Singapore on technology, when we have 5 wonderful judges from Singapore recently. And I told Meta on my smartphone, please give me a paragraph from a judgment as if it were written by Chief Justice Sundaresh Menon, the Chief Justice of the Supreme Court of Singapore. Just as a little bit of a, aside for a laugh. In literally 5 seconds, I had a paragraph, not written by the judge in any judgment, but produced by Meta, using, his style, his quality of thought. So, to answer your question in a more serious plane, just as technology creates solutions, it also creates problems. And therefore, the answer to these problems which technology creates has to be through use of better technological means to find answers to those problems, to having this problem about fake information or fake cases. Perhaps cross-checking. The problem was that, when, at least in the New York case was, the first step was the lawyer gave a written submission which had fake cases. Then when the judge went back to the library and tried to find out those cases. He couldn't find those cases. So he asked the lawyer to produce the cases. The lawyer went to the same AI-powered tool, and that gave him fake judgments also. So obviously the lawyer, it may or may not have been deliberate. So you have to be doubly careful. Due diligence is really the answer, and technology, I'm sure, will be able to find better tools for dealing with these problems.
So actually, just to add, while we were doing the jury metrics, Anish and me, we were working on it, and it gave few judgments which you were not quorum on, but it said that those were given by you. So we had to apply our natural intelligence to eliminate that.
Somebody was standing up there?
Yeah. Sir, so I have a question in two parts. You mentioned that rightfully so.
Do introduce yourself.
Yeah, my name is Ojas. I'm a fifth year at this college. You rightfully mentioned that AI, if used well, can reduce the workload of juniors. But as we've just discussed, AI is half-baked and that it has hallucinations, it contains false information. And jumping the gun on the inclusion of AI in the legal process can actually reduplicate the efforts of juniors and make their lives much harder, and they have no role in deciding whether it's incorporated or not. The second part of this question is that, again, AI is half-baked, there's minimal regulation on how AI is used, but it's already being involved in judicial and quasi-judicial processes. Just last month, the Income Tax Appellate Tribunal in, I believe, Chennai or Bangalore, had to recall an order because that order had four judgments mentioned by them which were hallucinated. They weren't real. So how do we ensure that a reliance on AI by the judiciary doesn't become an over-reliance, leading to a violation of the natural rights of litigants, and how do we ensure that it doesn't become overly burdensome on those litigating as well as those representing them?
You know, your second question, I'll answer that first. If you, for instance, simple thing, if I'll say asking for a brief of a case file, you get an AI-assisted brief, and then the judge is trying to use that AI-assisted brief summary to deliver judgment, and that gives you, some precedents. You still have to do the physical check of each of those precedents, or ask your law clerk or somebody else in the office to do that cross-checking through either SCC Online, or now we have the digital SCR, or if it's the High Court judgment using any of the High Court softwares. So that process of rechecking on whether such a judgment does exist using some cross verification is necessary. On the first aspect of your question, which is it is half-baked. Yeah, but I think though it is, I wouldn't exactly call it half-baked. Today's products are continuously improving. You have today so many young lawyers now who use, say, something like liquid text. I would always ask young lawyers who are appearing before me, what program are you using for your making notes or your arguments? If somebody would say, I'd use liquid text. I use Microsoft 365 for my for making briefs of the cases which were argued before us, because it was just loaded in my system. So the point of the matter is that what all these tools are doing is to make it simpler. For instance, suppose you have evidence in a case. I've seen that myself with young lawyers overseas, where evidence can be analyzed by an AI-assisted tool to break down the analysis. Who is the witness? Which are the witnesses who have spoken on the nature of the damages, on the claim for punitive damages, on foreseeable compensation. So under every head, the AI-assisted tool can basically give you what every witness has said with the paragraph numbers. Thereafter, the human has to go back to that paragraph number to see, what has been said where. But what this does is to really substantially reduce the basic work and the basic amount of time which is spent in doing purely manual work. I remember, when I was given a job at a US law firm. One of my friends who had already worked in that law firm, she told me that, look, most of our year was just spent doing manual jobs like pagination, carrying paper files. All that work now can be done by juniors. And my point really is this, that today, which is beyond AI, that today, one of the reasons why juniors are not paid well in the legal profession is that seniors have this misconceived notion, and that's with due respect to Mr. Kanitkar and Mr. Nayan also, Mr. P. Nayan, that there is an incorrect notion that juniors come to the legal profession to learn. And we as seniors are there to teach them something. I've actually, of course, I've mentored my own law clerks, a large number of them and interns who have passed through my chambers. But I've also learned that, juniors teach you as much as they learn. Mentorship and leadership is not about, the seniors teaching the younger people. But the younger people who have a real feel for reality, teaching the more senior people in the profession. So in that sense, allowing for the use of AI by the younger professionals like yourselves when you join the legal profession will enable younger professionals to do the core work of lawyers, which typically was left to others, to do the more senior people to do. I feel that work must be given to the greater responsibility must be given to younger people, and of course, which is my pet theme, better payment and salaries to younger people in the legal profession.
Thank you, sir. We would take one. Yes.
Good morning. I'm Amrita Awad from final year BLLB, and I have a couple of questions. First is we're grateful for the insightful lecture. In terms of AI's superior processing abilities and employing it for predictive analysis or cognitive decision making rather, how do we mitigate the bias that is historically impacting the marginalized communities, since the AI would be trained on the historical data? Since you've widened the, since you have opened the floor for other questions as well, I run an NGO dedicated to art and cultural heritage law, researching in subcontinent. And I want to know your views on rather sorry state of PMLA framework in terms of art and antiquities in India.
What is the second question?
State of PMLA framework in terms of art and antiquities, especially in the digital age.
You know, on the first question which you asked me, I think the answer to it really, in that sense, is, again, it's an answer which has to lie in technology, because if you are creating technology, then technology must necessarily provide an answer. So AI can't really be implemented without guardrails. It's known that, you know, a lot of AI, which is, as you rightly said, based on historical data, is therefore, you know, is therefore prejudiced against, say, women, because typically women have been the subject matter of grave prejudice in most societies. Likewise, minorities, racial minorities, it's like the African Americans in the US, possibly the scheduled castes and scheduled tribes. So, really speaking, there has to be a prejudice factor when technology is being developed to account for this element of prejudice. And there must be objective ways of deducing the prejudice which you find in historical data, so that you use then that prejudice factor as an applicable, you know, quotient in reducing the reliability of your, the reliability of the product which you are generating through AI. Your second question, honestly, is a very fundamental question. It's a question, again, of the law needing to, you know, keep pace with the rapid change with which, you know, everything is developing, particularly in areas of culture, art particularly, and the grave dangers to culture and art by, say, an AI-generated song or an AI-generated novel. Does it have copyright protection? So I think our law really hasn't kept pace with the times, and that's really a question of how lawmakers respond. And I'm not sure lawmakers are really equipped, because the law really is typically very slow to change. But the pace of technology has been so rapid that the law is struggling to keep pace with the regulation necessary in today's age.
Hello, sir. Sir, yes, sir. Hi, sir. I'm Kunal Behel from 5th BLLB, and it's an absolute honor and fanboy moment for me to be in the same room and ask you a question before my college life ends. Getting to the question, US courts have applied Compass management systems as like one of the software to check whether the risk assessment scores are given to individuals, whether they can commit the same crime again, and based on that score, they utilize that score in sentencing and bailing terms, right? Given the India, keeping the technical difficulties apart, I wanted to know your opinions on the application of software, AI software like Compass in Indian judiciary system, and what are on the ethical grounds and other perspectives, which I know that you'll obviously analyze issues from multiple perspectives. So what are your different perspectives other than the technical issues, keeping that as an hypothetical assumption that we are able to arrange the technical database of the criminal history and the personal background of individuals?
You know, speaking for myself, and maybe I'm speaking as an orthodox judge, because I belong to a generation, right? So please discount what I say as coming from a person who's relatively older in age. I'm very averse and very circumspect to giving tools like Compass to Indian judges to decide on sentencing. See, I mean, one of the considerations which you bear in mind when you grant bail is is there a likelihood of the accused either fleeing justice if they were to be granted bail, or committing the same offense while if granted bail. That's a very important consideration to bear in mind. Now, if the, if the entire process is replaced by an AI-assisted tool, that would mean that somebody who has multiple offenses in the past would really risk not getting bail at all, however small the offenses, merely because of the fact that somebody has committed a similar offense in the past and there's no likelihood of the trial concluding in the near future. Second, I think the American legal system is far more rigid in terms of sentencing than we are. I would be extremely, I think it would be unconstitutional to tell a judge that whether you would adopt, whether it's a rarest of rare case to award death penalty, will be defined by an AI-assisted system, however efficient it might be. This work, the essential work of, particularly in criminal cases, of analyzing the evidence, assessing the evidence, and a reasoned outcome, and finally on what should be the appropriate sentence according to law, has to be done by the human mind, however imperfect it is. So despite our imperfections of human mind, you don't want the kind of rigidity which AI would bring, nor would you want the kind of likelihood of bias. For instance, the facial recognition technology, FRT, which is used for policing now in many countries in the West, is again known to have a bias against racial minorities. So in a country like ours, which is so diverse, and the stability of our society ultimately lies in maintaining this plural culture, and you would not want any segment of the society to be targeted by use of AI in an excessive way.
Hello.
Hello, sir.
Hello. In one of your hello, here, sir. On your right, sir, yes. My name is Ketan Pawar. I'm working in ILS. My question is, in one of your judgment, M.K. Singh judgment, where you said, recognize. Yes. You recognize right against the adverse effect of the climate change under Article 14 and 21. So in Indian context, I want to know, how can that judgment, how can that be taken forward, not just formally, like going to the parliament and making law, but some, other than that, bringing some foundational change, so climate change becomes the part and parcel of the Indian system.
See, in Ranjit Singh's case, we were dealing with, the setting up of solar, for those who don't know it, solar power lines through an area in Rajasthan, which was the habitat of the great Indian bustard. The great Indian bustard is probably one of the largest known birds on planet Earth, and faces the grave danger of extinction. And the argument was that, the birds they have only a peripheral vision, and they can't come into contact with power lines, and they just drop dead. The government, of course, argued that that's not the only reason why the birds die. It's also because they lay single eggs. And they are basically left in grazing areas, and those birds are preyed upon by other predators on the ground, and it's not just because of the power lines. So we laid down the basic principle. We formulated this principle that the right to be protected against climate change is a fundamental right guaranteed by Article 21. We applied that in the context of the preservation of the great Indian bustard, and said that we constituted an expert committee to decide which are those core areas of the habitat of this bird on which no solar lines would be permitted, the intermediate zone where you will permit subject to restrictions, and beyond where you may permit them. Going forward, you're right, your question is absolutely spot on. How will this evolve in individual contexts? To what extent can an individual citizen say that I'm challenging this power project on the ground that it affects my right to be protected against climate change? The courts can really develop, innovative concepts like the doctrine of proportionality, which has been applied elsewhere, to place the burden on the proponent or the developer of the project to satisfy the court that all necessary steps have been taken to mitigate the impact on climate change, and to have an objective scientific assessment done on what would be the carbon footprint as a result of this particular project, and have the best possible mitigative measures within today's known source of knowledge being taken to reduce the impact of, say, the carbon footprints or the carbon emissions.
Thank you, sir.
Sir,
Sir,
my name is Mandar Abhyankar. My question is, we are speaking about AI outputs. How about regulating the companies and technology companies which are producing the input and regulating the algorithms? What is your opinion about that?
You know, my own point is that any such form of regulating regulating companies, I'm personally against it for this reason, that once you allow, regulating by whom? Regulation would be by the government, or government regulation would be by an institution. If you allow for this kind of regulation, you'd be really striking at the root of innovation. No innovation will take place if you regulate innovation. Regulation by itself should be free. Innovation by itself should be free of regulation. Now, yet it has to be responsible innovation. That would arise at the point when the innovation is actually being implemented on the ground by adopting products. And there, perhaps greater regulation can be enforced. For instance, as I said, setting up all these huge power guzzlers in the form of AI. In fact, of course, the Chinese have claimed that DeepSeek has, of course, been set up with a fraction of a cost and is not guzzle as much as power as say, some of the earlier models. But there, I think greater scope for regulation can be introduced, including, such as carbon exchanges, placing a greater degree of responsibility on the innovators to ensure that when you put your innovation into marketable ideas, there, the impact on the environment, the impact on, say, the spread of misinformation, the impact on issues which we have just discussed, like fake dissemination, can be minimized. And then place the burden on the innovators because if they have so much of innovation that they can generate the innovation, they can certainly then place adequate investment in safety, truth, and reliability, and authenticity. At that point, you can place greater burdens by regulation, but not at the source of innovation itself. That's my instinctive reaction.
Hello, sir. Good afternoon. Here. My name is Reeti Verma. It was a privilege to listen to your lecture. I have two questions. My first question is actually a follow-up to a question that you already answered, which is about the repetition of historical injustices that could happen in case the AI mimics certain patterns against certain communities. My question pertains to slightly deviating from the inclusion of AI within judiciary, but rather shifting it to also businesses, which would also ultimately come to the court for justice. So the question I have is, in case, say, certain financial entities, say banks, employ artificial intelligence to go ahead and say, and to take part, say, in bank loan approvals, right, by banks. A lot of these processes have had a history of injustice, say, against women and against certain communities, and hence it is likely that women are less likely to have an approval for certain loans. My question is simple, it's more legal in nature, I'm sorry for deviating. Is at a point in time when artificial intelligence cannot be held liable, who does the liability then fall on? But also at a point in time, we are giving the avenue for artificial intelligence to make a decision. We are giving it a responsibility. How can an entity that cannot be held liable be given that responsibility? Which is, we already disqualify individuals who we can't hold liable from making certain decisions or from contracting, as they cannot give free consent. How can we give that responsibility to artificial intelligence?
So, the answer to your question, your example, the answer is much easier. Suppose an AI-assisted tool is used by a bank to process loan applications. And as a result, the application is rejected. And it is found that most applications which have been rejected, or more applications of women have been rejected than of men, for the reason that a woman may not have the same financial security as a man who is applying for a loan. Now, that would show that your AI tool, which was applied by the bank, was inherently flawed. Who takes the responsibility? The generator of the AI? The generator of the AI will say, well, I have no proximity with the ultimate consumer of my product. There again, I'm not sure that that argument can be raised, because that the generator of the product should, in the reasonable course of human events, have known that their product is going to be applied in processing loan applications, right? Can the bank say, well, I'm not responsible because I only blindly trusted the generator of the AI product? Again, the bank can't be told that, the bank can't say that, well, I'm free from blame because I merely applied the AI tool which I got in good faith from someone else. As an institutional body, the bank has to be conscious of the fact, and it must be constantly monitoring how many applications, say, from minorities have been rejected, how many applications from women have been rejected. So bank has no defense. Your question actually has a very valid contemporary context. What about driverless vehicles, autonomous vehicles? If you have an autonomous vehicle which is purchased by an individual or by, say, a cab-owning company, and that vehicle commits an accident, who is responsible? The owner of the vehicle? The owner of the vehicle will say, well, I just trusted the AI software. Would it be the AI producer? The AI producer may not be the owner of may not be the person who has actually manufactured the car. The car manufacturer may be Ford or whichever international brand. The producer of the AI, which is used by the car manufacturer, would be somebody else. So again, obviously, these are extraordinarily complex questions which are confronting our times. And even today, despite the GPDR, I don't think that any global community has really found a clear answer to these problems, which autonomous armaments, where you have, say, a missile system which is operated completely autonomously. A missile is launched, the missile falls in an area where it was not intended to fall, and it causes deaths of, say, 10,000 people. Who is responsible? The country which launched the missile? Can it plead sovereign immunity in an international court? If there's a bilateral investment treaty, can they plead a defense? Is it the manufacturer of the missile, the manufacturer of the AI system which was embedded in the missile system? Or is it joint and several? Could you bifurcate the liability equally amongst different components? And if you were to execute such a decree, who would you execute it against? An AI producer in one country, the missile manufacturer in another country, the missile system manufacturer in a third country, the country which launches the missile, and the court's the country where the damage has been caused. So again, extraordinarily complex. I don't think the international community today has institutions for dealing with these questions at all.
Please skip.
नमस्ते सर, माझं नाव धैर्यशील आहे आणि माझा क्वेश्चन सर लेक्चरशी संबंधित नसून तुम्ही जे जजमेंट्स दिलेत त्या संदर्भात आहे. मला एक थोडंसं सर विचारायचं होतं. आता 150 कोटी लोकांच्या देशात आपण राहतोय, त्यामध्ये जर एक वोट मॅटर करत असेल तर ॲज अ ज्युडिशियरी जिथं लोकांमध्ये आत्ता जी इलेक्शन पद्धती चालू आहे, EVM असू, बॅलेट असू, हे करायचं ते करायचं, जर 30-40 कोटी लोकांच्या मनामध्ये जर ही साशंकता आहे तर ॲज अ ज्युडिशियरी तुम्ही त्याच्यावरती डिसिजन कोणत्या पद्धतीने घेऊ शकत नाहीत आणि का घेऊ नाहीत याचं मला सर आन्सर हवं होतं.
हे बघ, आता EVMचा तुम्ही उल्लेख केलात, EVMचा उल्लेख केलात. EVMच्या बद्दल सुप्रीम कोर्टात 2 नाही तर 3 वेळा याचिका आली होती. सुप्रीम कोर्ट जेव्हा निर्णय घेतो, आम्ही सुप्रीम कोर्टात निर्णय घेतो, हायकोर्टात निर्णय घेतले जातात. तुम्ही लोकांना विचारून निर्णय घेऊ शकत नाही. कारण लोकांना तुम्ही विचारायला गेलात, कुठल्या लोकांना तुम्ही विचाराल? तुम्ही म्हणाला 30-40 कोटी लोकांचा तुम्ही उल्लेख केलात. कुठलाही जज 30-40 कोटी लोकांशी बोलू शकत नाही. सो अल्टिमेटली ज्यांची केस असते, सरकारची बाजू असते. आता ह्या केसमध्ये इलेक्शन कमिशन ऑफ इंडियानी सगळा डेटा दिला सुप्रीम कोर्टाला. EVMs बद्दल सुप्रीम कोर्टाने सायंटिफिक डेटा मागवला. आता 2 नाही तर 3 वेळा जर का सुप्रीम कोर्टाचा निर्णय आला की EVMs मध्ये त्रुटी नाही आहे अँड द इलेक्शन आउटकम इज नॉट बीन अफेक्टेड अँड विल नॉट बी अफेक्टेड, वी हॅव टू ट्रस्ट द इन्स्टिट्यूशन. Because ultimately the Supreme Court is a final constitutional institution, is entrusted with this authority. आणि ज्यावेळेला आपल्याकडे EVM सोडा, ज्यावेळेला आपल्याकडे पेपर काउंटिंग होत असं, मी जेव्हा लहान होतो तेव्हा 2-2, 3-3 दिवस काउंटिंग चालायचं. कारण 8 लाख मतदारांची वोट्स काउंट करायचे असतात. त्यावेळेला वेगळे प्रॉब्लेम्स होते. बूथ कॅप्चरिंग, पेपर बूथ्स हॅव बीन, पेपर बॅलेट्स हॅव बीन कॅप्चर्ड. म्हणून असं नाही आहे की ती जी प्रणाली होती, ती पूर्वीची सिस्टम होती, ती काय परफेक्ट होती. सो एनी सिस्टम विच यू अडॉप्ट in any democracy, and I'm not just on EVMs, but on any other modality of public governance, will have to have a constant churning, and it's from experience that you learn how to make the system more perfect. But merely because somebody casts doubt on a system, to disregard the system will be very dangerous in democracy. म्हणून आपल्याकडे संस्था आहेत, कोर्टाची संस्था आहे, इलेक्शन कमिशन ऑफ इंडिया आहे, राज्य सरकारांच्या स्टेट इलेक्शन कमिशन्स आहेत. And you therefore have to go by the robust nature of the institution in every democracy.
Good morning, sir.
आर्टिकल 31A, 31B हे कॉन्स्टिट्युशनल अमेंडमेंटच्या मार्फत आपल्या कॉन्स्टिट्युशन संविधानात आलं. का आणलं त्यावेळेला? त्यावेळेला तुम्ही, आता आपण आज 2025मध्ये आहोत. 1950 साली, 55 साली, 60 साली लँड रिफॉर्मचं काम सुरू केलं सरकारने. अँड लँड रिफॉर्म्स वॉज अ व्हेरी इम्पॉर्टंट पार्ट ऑफ द पॉलिसी ऑफ द स्टेट गव्हर्नमेंट. आता सरकारला असं वाटलं की त्यावेळेच्या सरकारला की दर खेपेला जेव्हा कुठल्याही लँड रिफॉर्म लेजिस्लेशनला आव्हान येतं कोर्टात आणि कोर्ट ते स्ट्राईक डाऊन करतात, तर लोकांना जमीन कशी मिळेल? ज्यांनी खरंच जमिनीवर काम केलेलं आहे. आपल्याकडे महाराष्ट्र ॲग्रिकल्चर सिलिंग ऑन लँड्स ॲक्ट आहे, और बॉम्बे टेनन्सी अँड ॲग्रिकल्चरल लँड्स ॲक्ट आला. या ॲक्ट्सना जर का समजा आपण तो चॅलेंज झालं असतं आणि ते ॲक्ट जर का स्ट्राईक डाऊन झाले असते, तर ही जी सगळी सोशल रिफॉर्म घडली आपल्या देशात, ते सोशल रिफॉर्म झालंच नसतं. म्हणून आज आपण खरं त्याला आजच्या दृष्टिकोनातून बघण्यात ठीक नाही आहे. 1950 सालची जी अवस्था होती आपल्या समाजात, देशात, त्याच्याकडे आपल्याला बघण्याची आवश्यकता आहे. आणि तरीसुद्धा सुप्रीम कोर्टाने त्याच्यावर पुष्कळ बंधनं आणली आहेत सरकारवर. आर्टिकल 31B खाली ज्या 9th शेड्यूलमध्ये जेव्हा कुठलाही ॲक्ट आत इन्सर्ट केला जातो, तो प्रोसेस बेसिक स्ट्रक्चर डॉक्ट्रिनवर चॅलेंज करता येईल, हे सुप्रीम कोर्टाने म्हटलं. म्हणून आता अल्टिमेटली दिस इज अ मॅटर ऑफ चेक्स अँड बॅलन्सेस इन एनी सिस्टम, अँड वी मस्ट अंडरस्टँड द सोशल कॉन्टेक्स्ट ऑफ द टाइम्स इन विच दीज प्रोविजन्स वर ब्रॉट.
Can I ask a question?
Keep the mic.
You see, when the Shetty Commission gave its report, it was an idealistic philosophy that you must bring the most brilliant young lawyers to fill in a certain proportion of vacancies in the judicial service of the state. It was a very salutary idea at that time. But over a period of time, what you have found is that merely passing out of a law college does not give you the experience how to do the basic work of a judge, how to decide an Order 39 Rule 1 application, or how to decide an Order 6 Rule 17 application, how to decide a bail application. Now, there are a lot of judicial academies which have come up across the country now. Maharashtra has a very beautiful judicial academy. Justice Shalini Phalansakar Joshi was manning the judicial academy for a very long time. But notwithstanding this, you find that, a certain degree of practical experience in law is very important before you actually go to the dais. it also, without that experience, even the confidence of a person who becomes a judge is affected. As people who are appearing before you are people with far greater experience. And if someone has to be told by a senior lawyer how to, draft a small order, it affects the credibility of that judge. So there is much to be said in the new thinking which is now taking place, that some element of practical experience is also necessary before you join judicial service. Both Justice Sadhna Jadhav and Justice Shalini Phansarkar Joshi are here. I will request them, they may also share what they feel about this, because they have both served very long periods of time in the district judiciary. So we'll ask them, Sadhna, of course, has not in the district judiciary per se, but she came in from the, she worked in the civil service before she joined the, what is your experience, both Sadhna and Shalini? You can both.
Thank you. As Lordship has just said, practical experience is of far more importance, because in the academy also we have, in Judicial Academy, when the judges were directly recruited and sent to the academy, we often used to notice that they hardly know a single thing. I mean, CPC you know, but the importance of temporary injunction, day in and day out we are coming across such applications. Day in and day out as a judge you are dealing with remands of the accused, police custody, magistrate custody. There is one single section, but how it is to be applied, how you are going to do with section 167. Hardly anyone know what to give the, how to give the bail, PR bond, nothing. I mean, that is only you learn from the practical side. So some sort of practice is utmost necessary. Even in the academy, therefore, we started using this practical side by conducting the moot trials. Then we were giving them the exercises of writing the orders on such applications for remand, bail, for interim injunction, stay, appointment of commissioner. So many practical aspects for which really the practical knowledge or practical side is necessary. And therefore, as we have rightly said, yes, it is necessary.
Just before I retired, I came across a case where the lawyer for the appellant argued for just 2 or 3 minutes. And when I called upon the lawyer for the respondent said, look, I want my client to succeed. But I don't want my client to succeed on a wrong ground. Because the ground on which I have succeeded is embarrassing even to me. He says, this is not the ground on which, this is the most unstatable of grounds on which I could have succeeded in this matter. But please don't therefore set aside the judgment on merits, because my client will suffer for a point which even I didn't argue. So these are the aspects which arise, if a person without experience is because you are just placed in the hot seat and there's so much that you learn from just observing seniors in the court. Not being taught in the court by a senior. Just by sitting in the court and watching somebody else argue, you learn what to do in a court, what not to do. You learn how a judge is conducting a case in a court. You also learn the interpersonal skills. How is a judge handling a difficult lawyer? How is a judge handling a case which has, a certain degree of complexities? It's not just about substantive law, but also about procedural law, the actual handling of clients and cases in court. So some degree of experience is really crucial.
Good morning, sir. So good morning, sir. So I'm Jay Nene. Sir, good morning, sir. I'm Jay Nene, a young lawyer with a young law firm, Legal Logic. I'll start by expressing hope and gratitude. So you have unparalleled connection with technology and young lawyers, and that gives me hope. And that sort of leads me to 2 questions. The first question is, we spoke about democratizing access to justice and how judiciary is doing it. What would be your wish list or guidance to lawyers, and especially young lawyers, as we move forward and serve clients? So that's one. And second is, what would be your take on evolving the digital rights. We spoke about algorithmic echo chambers. We spoke about harm and digital and fundamental rights. Do you think there is a need for self-correction in terms of how digital rights are being seen? Yes.
I'll answer your second question first, which is a easier question. Of course, there's a reason for a need for self-correction because we are now seeing the flip side of technology. So as we go forward, there's a need for self-correction. So I couldn't agree with you more. On your first question, on democratizing access, my concern in the legal profession really is this, that, the legal profession is like no other profession. It's a profession which is basically a profession founded on service to people. But we are not creating, and we have not created, a stable framework for young lawyers to succeed. Even today, our profession remains very largely feudal. We have not created merit-based opportunities for young lawyers. That's why you find so many young lawyers coming in from good law schools are moving away from the legal profession, in the sense that, the core of the legal profession, which is court-oriented work. That trend is again changing now. More and more young lawyers are now coming into the court profession, which is a very heartening process which has started in the next few years. Because, transactional lawyering has its own difficulties and its own problems. But I think there is a great responsibility which lies across the spectrum on professionals in the legal profession, because this change cannot be brought in merely by legislation, by merely amending the Advocates Act. This change has to be brought about within the legal system itself by creating proper roles for young lawyers. The great deal of responsibility lies in judges. Throughout my career, I made it a point, if I found a young junior appearing before me, to spend 5 minutes more in encouraging that young junior, even if they were not really very confident about the case. Responsibility lies with seniors, not so seniors also. There's no greater learning than peer learning in our profession. You learn from your own peers. So we need to create these avenues for young people where they can find the legal profession more sustainable and don't leave the legal profession, which you otherwise find is happening.
Thank you so much, sir. We're really humbled with all your... I'm sure there are a lot of questions. We have our subsequent sessions to be conducted. I would request all of you to note down your questions and we'll be mailing it to sir. And I'm sure sir would be answering them. One last question we will take. Okay. This will be one last.
Hello, sir. हॅलो सर, माझं नाव श्रीराम जाधव, LLB थर्ड इयरचा स्टुडंट आहे मी. सर, आपण म्हटलात की ज्युडिशियरीमध्ये आपण AIचा वापर करतो, पण आज आपल्याकडे आपल्या देशात सायबर फायरवॉल नाही आहे. इव्हन पाकिस्तानकडे सुद्धा सायबर फायरवॉल आहे. तर मग आता डाटा प्रायव्हसी आणि सिक्युरिटीसाठी आपण काय मेजर्स घेणार आहोत?
आपल्याकडे डेटा फायरवॉल आहे.
हां.
We have data firewalls in India. I know, as a matter of fact, how could we operate a system without a data firewall? But a data firewall is always work in progress because the hackers are always ahead of the times. So we all have, and no institution across the world has been free of, security breaches. But to say that आपल्याकडे data firewall नहीं है is not correct. We do have data firewalls.
Sir, but national firewall नहीं है आपल्याकडे.
And that is why, in fact, as I said during the course of my presentation, I constituted a committee chaired by some of the top domain experts in India outside the judiciary to continuously review what we need to do to improve the element of data security, because we are holding the data of citizens in trust. So it's not something we can do without a data firewall.
Yeah. Thank you,
Okay.
sir.
Thank you so much. We would get an opportunity to ask questions. Please respect the schedule and the decorum. We are moving ahead with the last component, sir, before we conclude today. We have a special glimpse into the world of artificial intelligence, not through high-end machines, but through a creative ingenuity of young minds. These robots were built by and programmed by small students of RoboMinds for the First Take Challenge of 2025 National Championship, and they have won the Robot Game Finalist Alliance Captain's Award and Think Award. Beyond competition, the team is dedicated to promoting STEM education, especially among underprivileged children and girls, through their initiative like Give Back Sundays, where they provide ongoing robotics training to the community. These robots built for a game may seem simple, friends, but they represent something far greater, a foundational step in AI's journey from automation to intelligence, from assisting in tasks to making decisions. I request RoboMinds to begin with their demonstration. So just as these robots are designed to navigate games challenges, AI in governance and justice is being trained to navigate real-world complexities, which few of them Justice Chandrachud just now pointed, and also assisting in legal research, predicting case outcomes, and streamlining the judicial process. This demonstration, friends, is not just about robots playing a game. It is about understanding how AI starts with the basics and gradually evolves into a transformative force. So with that, let's take a moment to appreciate the work of these young innovators. We are just demonstrating it for the people who cannot see. Can the lights be switched off on the dais, please?
And put them in this basket, each earning you a certain amount of points. So this was just a showcase of how the games work. There is obviously much more nuance and many more tasks. For example, you have to ascend onto a yay-high submersible, for which we've created these ascent hooks. And yeah, this was just a small demonstration.
So, would Justice Chandrachud want to have hands-on with the robots?
From that point, we start building our robot. Yeah. So it was just last week for this season. No. So we go to different schools, but we come to a club called RoboMinds to learn robotics. Chris is the founder. They're the founders. So we learn robotics there and participate in competition. So we're all in different